let me call those three cases. Let's get started on one of them anyway. So let's, first case is Timothy Brewer, 18-17153-DS, and then we have a number of other ones, but I'll call those in order. Are you Timothy Brewer?
I am, Your Honor.
All right. There are three cases that we have with you, all involving child support. And I'm going to call them one at a time just so we can keep a proper record for them. So there's going to be three of these processes that we have to go through together, just so that you're aware. We are here on this case, which is the case involving Amanda Lane first, and that's file 2012-14613-DP. Nope, sorry, I've got the wrong one. I think I called the 18 case. So let me get to that one. This is the case involving Mary also Brooks. All right, Mr. Brewer?
Yes.
So that's the 2018 case involving Mary. The allegations in this are that you've already posted a $600 bond in February on this case, and this hearing today is to address the issue of contempt and forfeiture of the bond, and to show cause why you shouldn't be held in contempt for failing to pay the previously ordered support. And there is an arrearage in this case of $1,051.26 as of the paperwork date of February the 14th, I believe, of 25. So tell me why you haven't been making your payments on this case.
Well, I believe I have been making payments. I mean, I make payments at the friend of the court, and I do believe it gets divided equally. I mean, so I have been making payments. I guess I just went through a separation after 8 years, got thrown out of my family home and had to move. So I've had some life, some things going on in life, but I have been trying to make payments. I guess, Your Honor, I do realize they have not been regular. So I do not want to mislead you and think I have made regular payments. So I guess I have missed some payments.
All right. You posted a bond in this case of $600. Do you have any objection if we use that $600 bond towards your arrearages? That would reduce it down from approximately $1,000. 600 off of that would put you down in the $400 range, which would be a little less than your past due amounts or your normal balance that you have to pay.
Your Honor, I have no rejection. I also was going to make a payment today at the friend of the court.
How much would that be?
I was going to pay $100 at least, maybe $150, but for sure $100 payment.
Your Honor.
Yes.
There has been no payments on this case since May of 2022. That amount was $20.14. The defendant does have the two additional cases. Partial payments have been made, but they've always been made by a third party. And it's been indicated to them that they were to make him aware to contact us, because depending on how charging cases are and arrearage cases, when monies are not made specifically to a case, they disperse to the charging cases first.
Okay, does that make sense to you, Mr. Brewer?
It does, Your Honor. My understanding was that it was dispersed equal to all accounts, not just accounts that were still charging. So I was misunderstood that.
All right, so we're going to post the $600 that you've paid previously in a bond. We're going to forfeit that, and we're going to set that as a payment in this particular case. When you come into the friend of the court today, Ms. Kraus, does he need to designate the $100 on this particular case? And can he do that? Can he post it to one case?
He would need to be present because there's a voucher that he needs to complete with a signature identifying that that is his request. Otherwise, it will disperse the way that I had just explained.
All right. Do you understand that, Mr. Brewer?
I do, Your Honor.
All right. If you're willing to do that, I'm not going to hold you in contempt on this case, because I believe that the $100 payment and the $600 payment shows your good faith in this particular case. So I don't need to hold you in contempt. So by the end of today, 4:30, are you going to be able to get to the friend of the court's office prior to 4:30?
I will be. Yes.
All right, so prior to the end of business today, there needs to be $100 additional payment towards this file. And we'll forfeit that $600 and put that towards your balance in this file as well. All right, Ms. Kraus,
Your
do you
Honor.
understand? Yes. Anything else,
Would
Ms.
it-
Kraus?
Would it be at all appropriate to just request to possibly adjourn this out a month? And if he was to pay the balance in full, we would just dismiss this proceeding. Because I think based on him making the bond payments, there should be no reason that he's not able to pay off the remainder of the balance in the next month.
So with basically it would be $700 today. You would owe about $350 or $351 for the subsequent month.
$351.26. Yep.
Yep. Are you able to do that, Mr. Brewer?
I should be able to, Your Honor. I should be able to. Yes, I can do that. 300.
All right.
Can I get an amount there? Was it again
Well,
three?
It would be,
Three.
oh,
Go ahead,
sorry.
Ms. Kraus. Go ahead.
The remaining balance after the bond forfeitures would be $451.26. He indicated he would be paying $100 today. So we would just request that additional $351.26 be paid before the April 23rd hearing in front of you. Does that make sense?
It does to me.
All right, then that's what we'll do. So we'll adjourn this file, the 18-17153 file for a month. We'll forfeit the $600 today. There'll be a $100 payment today, and then there will be a balance of $351.26, was it? Payable within a month.
$351.26.
All right. So next we will call the matter of Mr. Brewer and Amanda Sue Lane. That is 12-14613-DP. In this case, it appears that there has also been a $600 cash performance bond posted. However, the defendant still owes approximately $8,000 in unpaid and past due amounts. There is a current amounts to be paid every month of $372. And this hearing is to address the issue of contempt and forfeiture of the bond. Mr. Brewer, any additional information you want to give me on this case involving Amanda Sue Lane?
I do not believe so, Your Honor. I mean, I obviously have no problem with the bond being forfeited. I also, me and Amanda, we talk often. She had indicated to me that she was going to come in and waive the back child support on this matter.
I am not aware that that's been accomplished or has been done. Ms. Kraus, do you have any information on that?
That has not been done, but there are specific procedures in regards to handling that.
Yeah. And she has done it in the
Paperwork to be
past.
required. All right. Can you make an additional payment over that $600, Mr. Brewer?
Probably not today, Your Honor, but by next Friday I can.
How much would you anticipate there?
I can pay $100 on that one by next Friday. Now, if she comes in and takes the steps to take care of that back child support, could that change? Well, no, because I think I would still owe the state. So that $100 could go towards the states.
That's correct. There are statutory fees of approximately $539, medical support of $748, and additional costs and fees of $300. So we're looking at $1,500 that probably can't be waived. And again, I'm not requiring her to come in and do anything on those things. That's entirely up to her.
Absolutely. Yep. Absolutely.
So Ms. Kraus, similar to the other case, you want to adjourn this for a month and see if he makes the $100 payment and then comes in, he's going to have to make another $372 payment. Would that be, or what else would you recommend?
We would actually be requesting contempt at the next hearing. We would request a contempt hearing.
Okay, so we just want to adjourn it a month and see if he makes his payments and then go from there?
That would work.
All right. Mr. Brewer, do you have any questions about this case? Basically, we're going to forfeit the $600, require a payment next week of $100 and then adjourn for 1 month. and see how whether or not you've made your normal payment of $372. And if you do, typically we would adjourn it again. As long as you're making your payments, well, we wouldn't have any additional problems.
Absolutely.
Ms. Kraus, does that $372 involve any arrearage amount?
It does not. Potentially, we could address, if possible, to request an ordered on arrears of 186, or we could address that at that next hearing.
Why don't you send him a proposal on all three of these files as to ordered on arrears amounts and see if there's a way that we can work something out. I don't know what his current income is, and that may need to be a conversation that you have with him as you're determining what that ordered arrears amount is as to what he can afford. But let's do that in the next month, and then when it comes back before me again, he'll at least have some input into that, and we'll be able to decide that at that moment.
Yep, I would request that he contacts our office. It does seem that in prior attempts to contact him, I haven't been successful.
All right, Mr. Brewer, do you understand what I'm asking you to do?
I do, Your Honor.
Contact a friend of the court's office to discuss payments on the arrears.
All right.
And that's what she called an ordered on arrears amount. So that would be your current child support is $372. That would be an amount every month that you would pay in addition to that to start paying on that back amount that you owe. Now, if there's a waiver of that, that can be taken into account because that may lessen it somehow, but there's still going to be those state fees that are there no matter what. So we need to have some payments being made on the arrears amount.
Absolutely.
All right, so that will be the Amanda Lane 2012 file. That will be the order of the court in that one.
Your
Ms.
Honor,
Kraus, anything else?
Yep, just
go
for
ahead.
clarification, if Mr. Brewer and myself do come up to an agreement, would it be appropriate to send an order if that ordered on arrear before then for signed to be placed
Absolutely.
in the file?
I'd be happy to sign that if there's a consent agreement.
Thank you.
And then finally, we're going to hear the matter of Mr. Brewer in file 16-16267-DS. And that is the case involving Heather Ford. In this case, Mr. Brewer owes, looks like $21,098.43 in unpaid and past due amounts. He has a $376 current amount paid. There is a $3,000 performance bond that was posted on February the 12th. So the hearing today is to determine whether or not we should hold him in contempt for failure to pay and whether or not to forfeit the bond. Mr. Brewer, as to this particular case, any additional information that you want to give to me?
Your Honor, no, there isn't. Besides, the only thing I want to say is I spoke with Miss Ford in October. Janie is our daughter together. She's the only daughter I don't see. They're supposed to, she showed me, she has papers. There's supposed to be an adoption. She is supposed to be adopted by her new husband. And that adoption was supposed to be going through. She showed me the paperwork that she had it and had started filling it out. I don't know if the caseworker knows anything of it or what more. I know I have not spoke with her about it since.
All right. If there is an actual adoption, your rights to the child would be terminated, and once an order is entered terminating your rights to the child, then the child support typically would cease concurrent with that court order, and then the friend of the court would be directed to stop on any ongoing child support amounts. The back owed child support, however, would still be owing. It would all be arrears at that point.
Right, which she was saying that she was gonna erase those arrears too when the adoption took place. So, but I obviously realize if none of that's happened yet, until it does, till that paperwork's filed, it's still owed.
Right, and there are still medical and statutory and other costs and fees that would not be available to be waived. So there would still be an amount that you would have to have paying back over time. So it would be important for you to speak with the friend of the court about those. So do you have any objection to the court forfeiting the bond and applying that towards the arrears?
Absolutely not, Your Honor.
All right, so we will do that. Is there any additional amount that you can pay over this next month?
Well, I intend on definitely making $100 payment every Friday for sure. So, I mean, if I need to direct one to that case, I can definitely do so.
I think it would be appropriate to do that.
Okay.
And then you can contact the friend of the court again, just like the other file, and
Yeah.
discuss arrears
Absolutely.
and come up with an amount, hopefully reach an agreement on that amount. Even if you have to come up with some amount just on the statutory arrears and wait, if you can't figure out when the waiver or might be, I don't know, but you guys can discuss all of those things and come up with an agreement between yourselves. Ms. Kraus, anything else that you would like to do in this particular case?
Nope, as long as we were able to reach an agreement, then potentially at the next hearing, but if not, we would also be seeking contempt.
All right. So, Mr. Brewer, you understand that you need to get a hold of the friend of the court on all three of these files. You need to make an additional $100 payment sometime this next month on all three of these files. And
Absolutely.
there is the issue of arrears payments that need to start being made. So they need to start looking for an agreement. Now, I'm not going to require you to reach an agreement with the friend of the court, but if you can't, they do have the right to ask for contempt in the next monthly hearing that we have, which will be rescheduled for. All right.
All right.
All right. So we go ahead. Anything else, Mr. Brewer?
No, Your Honor.
So we will forfeit the bonds in all three of these files. We will adjourn 1 month in all three of these files. There will be an additional $100 payment during that during that 1 month adjournment. And you still need to make your normal monthly payments for that as well. And then you guys will work on reaching an agreement in all three of these files as to arrears. All right, I think that resolves all of those cases for this time period. Thank you very much, Mr. Brewer. You're free to go.
You have a good day, Your Honor.
You too.